Welcome to this presentation on crimes. In this lesson, we will be discussing different types of crimes and we'll be discussing the elements of crimes in general and elements of specific crimes as we go through the lesson. Now remember when we discussed briefly the difference between civil law and criminal law. In civil law, we focused more on the person who had been wronged and the wrongs against individuals or entities, and that the burden of proof was preponderance of the evidence. But now we're shifting over to crimes and criminal law. So the focus is on the wrong against society, and the burden of proof is much higher at beyond a reasonable doubt. We're also back into the labeling and the terminology of guilty and not guilty, whereas in civil law it was liable and not liable. So now we're going to be discussing crimes and whether or not a defendant would be guilty or not guilty. So let's take a look at some of the types of crimes that we'll be discussing. There are generally two types of crimes, felonies and misdemeanors. Now, when you get an opportunity to take a look at our guest lecturer, he will include a third type of crime, infractions. But in this lesson, we're just looking at felonies and misdemeanors. Felonies are much more serious, and they also include a punishment of more than a year in prison. And since the Eighth Amendment has still been considered constitutional with regard to capital punishment, felonies may also be punishable by death. The other type of crime is a misdemeanor. These crimes are less serious and generally punishable by less than a year in jail and or fines. So felonies, again, are much more serious and misdemeanors are not as serious, and really the difference lies within the punishment that is imposed on each of those types of crimes. Every crime has three different elements. Those are the actus reus, the mens rea, and causation. So let's take a look at each of those elements one at a time. The first of the three elements of a crime is actus reus. Now this is the physical act of the crime. Easy to remember because the word act is in actus reus. So it is the physical act of the crime. If it was a crime against a person, it would be the physical act of bringing the bat down on someone's head, or the punching them in the face, or something like that. Or if it was a theft crime, it would be the physical act of taking the property. So it is the actual physical act of whatever crime it is. The next element of a crime is called mens rea, and this is the actual mental state of the crime, which can also vary from crime to crime. Every time I hear mens rea now, all I can think of is Legally Blonde when Elle Woods is in the courtroom and starts educating the judge on what mens rea is, claiming there was no mens rea in the case that she was now taking charge of. There are three types of mental states for mens rea: intentionally, recklessly, and negligently. Intentionally means that the mental state was knowingly and willfully. The defendant knew what he was doing and was doing it knowingly and willfully, and basically trying to commit the crime with the intended consequences. The next one, recklessly, means that it wasn't necessarily done on purpose. The act or the mindset wasn't that they desired a particular consequence, but it was done with such a high probability and degree of risk that that particular harm would result. So this is often like the going into a crowded theater and yelling fire. Now, it was reckless, and you weren't necessarily hoping that someone would get hurt, but there is still that high probability and degree of risk of harm when people start to rush out and stampede, and it would result in people getting injured. Or going into a crowded movie theater and shooting a gun up into the air over everybody's head. Well, what goes up, yep, must come down. So even though they had no intention of hurting anyone, there still creates that high degree risk of harm is going to result because the bullets will come back down. Or the other example of the gentleman who decided that he was going to drive his car through the crowded farmer's market. Well, he may not have intended to hurt any particular person, but driving your car through a crowded group of people is certainly going to create a high probability that someone is going to get hurt. So that would be recklessly. The last type of mens rea is negligently. And we've already discussed negligence at length, but in this context, negligently as a form of mens rea means that you had the lack of reasonable care and were just not acting like a reasonably prudent person when committing that particular act. So those are the three the element of mens rea, the three different mental states for the element of mens rea. The third element of a crime is causation. There always needs to be a causal link between the defendant's act and the harm done. Just like in negligence, we had the actual and proximate causation element, it's much the same here in criminal law. The act needs to cause the outcome. So there is an old rule that we have that's the year and a day rule. That, for example, if you shoot someone and they don't die, but they end up in the hospital and they're in a coma, and a year goes by, but they're still alive, but yet they're in a coma, and then they finally die right at 365 days, the law says that that still is enough to prove causation between the act and then the eventual outcome. And that is the old rule, a year and a day. It has to be less than 1 year and a day in order to satisfy this particular element of a crime. Now you can kind of understand how this could be a little bit of an issue, particularly in today's day and age with medical advances and technology available, that you could sustain someone's life a little bit longer than a year and a day. So many states have created their own statute with different criteria, but many also fall back on the common law old rule of the year and a day rule. I just wanted you to be aware of the year and a day rule, and regardless of what state the defendant is in, there still has to be a causal connection between the act and the eventual result. Regardless of what the statute timeline is, they still have to prove the causation. So that is the last element of every crime. So let's begin talking about specific crimes, and we'll begin with crimes against persons. In talking about crimes against persons, we'll be discussing two particular crimes, murder and manslaughter. Now that's not to say there's not other crimes, but we did cover some of those in torts. We talked about assault and battery and false imprisonment, in particular in our intentional torts lesson. Now as they are intentional torts, they are also crimes. Generally, they are the same elements, assault and battery. In false imprisonment, the only element that's different is the awareness of the false imprisonment. In criminal law, you do not need to be aware of the false imprisonment, of the confinement. You do not need to be aware of the confinement. In kidnapping, kidnapping is a relatively easy crime with regard to the elements. Kidnapping is false imprisonment plus movement. False imprisonment plus movement. That is the definition for kidnapping. So you have all the elements of false imprisonment, the unlawful confinement of another, but now you're moving them. So if you confine someone, if you tied them up, that would be confining them. But then if you put them in the trunk of the car and started to drive away, that would be kidnapping. Now the distance doesn't matter. The distance doesn't make any difference with regard to kidnapping. It doesn't matter how far you move them. So if you took them out of the house and took them next door to the next house, that would still be kidnapping. So the distance is irrelevant as long as there's movement. And that's kidnapping, false imprisonment plus movement. All the other ones, assault and battery and false imprisonment, we discussed in intentional torts. I won't be testing you on those three as crimes because we already discussed them in intentional torts. So the crimes against persons that we will be discussing and spending some more time on is murder and manslaughter. Before taking a look at murder, we must first differentiate the difference between homicide and murder. They are not the same thing. All deaths are not necessarily murder. Homicide means the killing of one human being by another human being. Well, not all those situations establish the crime of murder. There are circumstances where someone dies at the hands of another person, but it's not necessarily murder. This could include self-defense cases, or, again, as we mentioned before, capital punishment. It is still legal in the United States, and so lawfully or legally, it is still not murder, but it is the death of one person at the hands of another person. So not all deaths are murder, but all deaths at the hands of another person are homicides. When they call in a homicide detective to a crime scene, like you see on TV, their job is to first ascertain whether or not this death that was clearly at the hands of someone else was murder. So they don't necessarily go in and all of a sudden say, oh, he died at the hands of someone else, so it's murder. That's not their job. First, they have to determine whether or not the death was going to amount to murder by investigating the facts and trying to determine what really happened. So just be cognizant of the differences between the terms homicide and murder. So not all homicides are murder, but all murders are homicides. So now that we've established the difference between those, now let's take a look at the elements and how to establish whether or not a homicide is murder. As I stated, all murders are homicides because murder is the death of a person as a result of the acts of another person. There are generally 4 different ways to establish murder, and they focus primarily on mens rea. So there are generally 4 mens reas that help us to establish the crime of murder. Those ways are the intent to kill, the intent to cause serious bodily injury, a reckless disregard that a death will result, and the felony murder rule. So let's take a look at those individually. The first way, the intent to kill. This one's pretty obvious. If you intended to kill someone, then you have murder. Your intent is there. You intend to take the life of someone else. That would probably be the easiest mens rea and the most obvious way to establish murder. The next way that we can establish murder is the intent to cause serious bodily injury. Well, this means that if you approached someone and you had a lead pipe on you and you started beating up this person and hitting them over and over and over again with the lead pipe, you didn't want to kill him, you just wanted to beat the crap out of him. Well, if he dies, that's murder. If the victim dies as a result of you beating them up with a lead pipe, then that's murder. Even though your intent was to cause serious bodily injury and not death, it still creates the necessary mens rea to establish murder. The next way that we can establish murder is the reckless disregard that death or serious bodily injury will result. This goes back to the example that I mentioned earlier with the going into a crowded theater and shooting a gun over everybody's head. There is a reckless disregard that someone is going to get hurt badly or that someone will die. So that would be your reckless disregard that death or serious bodily injury would result. This is also the driving through a big crowd of people with your car. You may not have intended to kill, but you're having a disregard that someone will get hurt when you're taking your car and driving through a group of people. So even though, again, you may not have intended to kill someone and you may not have intended to cause serious bodily injury, but driving your car through a crowd of people will certainly create that high degree risk of harm and therefore will establish the necessary mens rea for murder. The last way to establish murder is what we call the felony murder rule. The felony murder rule. The felony murder rule says that if someone dies during the commission of an inherently dangerous felony, then you are at murder. If someone dies during the commission of an inherently dangerous felony, then it's murder. Someone goes into a bank and they rob it, and as a result, when they're leaving, somebody shoots the guard on the way out the door, that would be felony murder. So even though your intended crime was the robbery, a death resulted from committing that felony, and therefore it's murder. This includes the getaway. If you rob from a bank and the cops show up and they begin chasing you as you leave the bank and you jump in the getaway car and you're cruising down the road and you get into a car accident and someone dies in that car accident, that is still during the commission of the crime. It's still during the commission of the crime, and therefore it's murder. The crime does not end until you've reached a safe haven. So the getaway still is considered to be a part of the commission of the crime. So the getaway is still part of it, and if someone dies during your getaway, then it is still part of the crime and therefore would fall under the felony murder rule. If, for example, someone sets a fire to a building that they think is empty, and unbeknownst to them, there were a couple of homeless people squatting in there to keep warm, and they set the fire to the building and those homeless people die as a result, that is during the commission of a crime. The felony being arson, and the deaths resulted during the commission of that crime. So those would be felony murders, and that's how you get to murder by way of the felony murder rule. So those are the 4 different ways to establish murder, focusing on the mens rea element of a crime. The next crime against the person that we'll talk about is manslaughter. Now, there are two different types of manslaughter. There is voluntary manslaughter and involuntary manslaughter. Let's begin with voluntary manslaughter. There are a couple of different ways to establish voluntary manslaughter. The first way has to do with the frame of mind of the defendant. So let's say you go walking home and you're looking forward to a nice dinner, and all of a sudden you get home and there's no dinner on the table and your spouse is nowhere to be found. And then all of a sudden you hear this noise upstairs and you make your way upstairs and you see your spouse in your bed with your best friend. So you walk over to the cabinet, you pull out your Glock, your pistol, and you shoot him dead. Okay, well, let's look at the elements of voluntary manslaughter. You have an intentional homicide during the heat of passion with adequate provocation without a cooling off period. Well, would you say that seeing your spouse in bed with your best friend created a heat of passion? A heat of passion is being under the influence of such intense, profound emotions that you're just not thinking straight. This would be a heat of passion. So walking in on your spouse with your best friend, and then you grab your pistol under the influence of that passion, would probably qualify and establish this particular element for voluntary manslaughter. The next element of adequate provocation. You are going to have to establish now that you were adequately provoked when you walked in and saw your spouse in bed with your best friend. And what do you suppose the standard of care used to determine adequate provocation? The RPP standard. The jury will have to then decide whether or not those circumstances are such that a reasonably prudent person would have been adequately provoked. Would walking in on your spouse while they're in bed with your best friend create a provocation that any reasonably prudent person would feel in the same or similar circumstances? That's what needs to be proven to the jury. Generally speaking, probably walking in those circumstances could probably be considered adequate provocation. The last element that you have to prove for voluntary manslaughter has to do with the cooling off period. So when you went upstairs and you saw this taking place in your bedroom, and you immediately went over to the drawer to grab the pistol, there wasn't really a cooling off period. You acted immediately. But let's say that instead of doing that, you went downstairs and you sat down on your couch and you put your feet up, you had grabbed a beer and you start watching TV and you're thinking to yourself, wow, that really sucked. And you know what? I'm going to get back at both of them. My gun's upstairs right there next to them, but you know what? I'm going to let them finish first. Let them have a good time. They can finish. I'm going to drink my beer. It'll be fine. I'll just wait. So you're waiting and you're waiting, thinking, okay, they're going to finish anytime soon. And you're waiting and you're still waiting and waiting and they're done. Then you go upstairs and you grab the gun and you shoot them. That would probably be outside of the cooling off period because you sat there and you had an opportunity to think about it and you started to come down. So you were cooling off. You had your wits about you to wait. That would probably be outside the cooling off period. Now I hear some of your heads. I know. And if you were in my class, you'd be raising your hand right now. There is an argument to say that while you're down there sitting on the couch, you start getting angrier. Well, but the fact that you turned around and walked away and then sat down still could create that outside of the cooling off period because there's no time limit. There's no statutory time limit that says, oh, well, if you waited this long, then you've cooled off. The cooling off period could be seconds, minutes, what have you. And the argument's going to be that you actually left the scene and went downstairs and sat on the couch. Now, just because you got angry again doesn't mean there was no cooling off period between being provoked at seeing them in bed to committing the act after you had sat down on the couch. So the cooling off period has to be such that there was enough time to go by for you to come down from that provocation and that heat of passion. So in the first example, when you first walk in and you grab the gun, that would probably be enough to establish voluntary manslaughter. In the second example, going down and sitting on the couch and waiting, that would probably not be enough to establish voluntary manslaughter. So then, if it's not voluntary manslaughter, what would it be? It would be murder. Okay, so if you don't establish the voluntary manslaughter because you did cool off, well, now you've stepped it up. So now it would be murder. That is the big difference between voluntary manslaughter and murder, is the heat of passion under the adequate provocation without the cooling off period. Now, like I said, the adequate provocation is an RPP standard. So that means if somebody just insults you and you just get so angry as a result and then you shoot somebody, that may not qualify because it does have that RPP standard. Okay, so again, it's an intentional homicide. That means that you did intend to kill him, but it was under the heat of passion after having been adequately provoked and you didn't have a cooling off period. Now, there is another way to establish voluntary manslaughter. So let's take a look at that briefly. Another way to establish voluntary manslaughter is under what we call the imperfect self-defense rule. Now, under the imperfect self-defense rule, somebody is still dead and it was at the hands of another person. But the defendant is claiming that it was self-defense. Now, under this rule, it is still voluntary manslaughter because you may have thought it was self-defense, but you were wrong. So under the imperfect self-defense rule, you're claiming that you had the right to self-defense, but it was a mistaken belief and the victim died. So if you look at self-defense and you're defending yourself, you better make sure that you have the actual right to defend yourself in those circumstances. Because if you're wrong, then you're going to find yourself in voluntary manslaughter. I'm going to talk about self-defense a little bit more in the next week's lessons when we talk about defenses. So just don't forget the imperfect self-defense rule because we'll look back at it or at least refer back to it when we start talking about self-defense. In this case, remember when I talked about the Barton case, when I talked about the road rage case? That's where this was. The defendant in that road rage case that I was talking to you about, that was the people that I knew, and I talked about it in jury instructions. Well, this was what the defendant was claiming right here. He was saying that he had the right to use self-defense because when he got to the car, he thought the gentleman was reaching in for a weapon, like a screwdriver of some kind. And the district attorney said, well, you were wrong, so that's the imperfect self-defense rule, and that's why he ended up in jail for voluntary manslaughter and not murder, because he had the mistaken belief that he could have used self-defense. So that is the imperfect self-defense rule. Let's move on now to involuntary manslaughter. The biggest difference between voluntary manslaughter and involuntary manslaughter is the intent. Involuntary manslaughter, when you went upstairs and saw your spouse with your best friend, you intended to cause them harm. You intended to kill them. Whereas in involuntary manslaughter, there is no intent to kill. You are not willfully committing that death. It is a non-purposeful killing. So this pretty much falls into the category of criminal negligence. This would look like your car accidents, and I'm not talking about DUI accidents, I mean car accidents that resulted in the death of another person. This would be a criminal negligence type case, which would land you at involuntary manslaughter. Now, as there is a felony murder rule, there is a misdemeanor manslaughter rule. This means that if a death results during the course of a misdemeanor, then you will be in involuntary manslaughter versus felony murder. If a death occurs during the commission of a felony, you're at murder. Here, if the death results during the commission of a misdemeanor, you're at involuntary manslaughter. So that is involuntary manslaughter, and we'll move on to crimes against property. The next group of crimes are crimes against property. The first set we'll look at have to do with habitation specifically, and those crimes include burglary and arson. There are 6 elements for the crime of burglary. I believe we touched on them briefly when we were talking about elements at the very beginning of the semester. So let's revisit them. Burglary is the breaking and entering into the dwelling of another during the nighttime with the intent to commit a felony. Let's go through them more specifically. Breaking. For the element of breaking, it does not require that there be damage. So you go up to a house and you use a battering ram to break open the door, that's pretty obvious. But it doesn't have to be to that extent. Breaking could include picking the lock. There's not any damage, but you're still breaking. Another example would be using a credit card to slide open the lock. That still, there's not any damage, but it still constitutes breaking. How about just turning the knob and opening the door and it's unlocked? Is that breaking? Actually, it is. Or how about opening up and sliding a screen door on a patio? Is that breaking? Yes, it is. What if the door is just slightly ajar and you put your hands on the door to open it further before walking in? Is that breaking? Yes, it is. So even though there doesn't have to be damage, it can still be a breaking if you move something from its original position. So sliding open an unlocked screen door, or opening further a door that's ajar, or even turning the knob on an unlocked door and then opening the door. You're still moving the door from its original position, and that will constitute breaking. The next element is entering, and you have to have both breaking and entering. So entering, you open up the door and you step in. That's an obvious entering. However, let's say you're walking down the street and you're carrying with you your handy-dandy fishing pole, because you carry it with you wherever you go, and you see this big bag of jewels on someone's dresser through the window. You slide open the window and you take your fishing pole and you flip it, and the line goes through the window and catches on to the bag of jewelry. And then you just crank your reel and in comes the jewels to you by way of your fishing pole. Now you never actually entered into the home, just the fishing pole and line. So does that constitute entering? Or let's say you've trained your dog really well and you see some jewels on top of a dresser and you open up the window and you send your dog in and say, "Fetch." And the dog jumps through the window, grabs the jewels, and then comes right back out again. Is that entering, even though you technically never entered? Well, yes, that is entering, because the fishing pole and the dog are extensions of you. So even though you didn't necessarily enter, you still caused something to enter. You put into motion what was entered, so they are an extension of you, and that will qualify as entering. It needs to be a dwelling. Now remember again, these elements that I'm giving you for all these crimes are common law definitions. So nowadays, things might be a little bit differently, but these are the common law definitions, and these are the ones I will test you on more importantly. Okay, back to the elements. Into the dwelling. It needs to be a dwelling, someplace where someone is living, their residence, their home. Now, the law did extend in common law. It did extend to buildings that were immediate parts of the dwelling. So places that were adjacent to the dwelling, such as your garage, which is just, inches away from your house. Or in the olden days would be your barn. It's still what they call the curtilage. You don't necessarily need to know that word, but meaning that it is the buildings that are in the immediate vicinity of the dwelling, because they would be in danger also being so close by. And having someone in the attached garage to your house could still have the same effect of scaring you when someone's burglarizing your home. So the idea is that it needs to be a dwelling or any immediate attached building to your dwelling. Now notice that it does not include commercial buildings or warehouses or anything like that in common law. Now currently in modern times it does include that, and how they did that was they broke it up into degrees. They have a first degree burglary and a second degree burglary. And the first degree being dwellings and residents and homes, and the second degree being commercial warehouses and whatnot. But again, for purposes of your test, if it's a commercial building or a warehouse, then it is not a dwelling and therefore not burglary. The next element is of another. It needs to be somebody else's home. The law figures that if you're going to go and break in to your own home and steal something, then you're just being stupid. So it does have to be burglarizing someone else's dwelling. It cannot be your own house. The next element is during the nighttime. Again, a common law element, and it means from sunset to sunrise. That is the definition of nighttime, from sunset to sunrise. So that means that the breaking and entering into the dwelling needs to happen during the night sometime. Otherwise, it's not going to be burglary. The last element, which is very important, is the intent to commit a felony. So there's two parts here: the intent and the felony. With the intent to commit the felony, it's important to note, and you might want to bold this part or underline this part or put a star next to it, because I'm going to probably try to mess you up on this, is that the intent to commit the felony is triggered at the time of the breaking and entering. That means that when you broke through the door and entered the home, you had the intent to commit a felony. At the time of the breaking and entering, you had the intent to commit a felony. So in other words, if you went into the home and you were there with some friends and you were just sitting there watching TV and you're thinking to yourself, wow, that's a really nice screen TV that he's got there up on the wall. I think I'm going to steal it. Well, that's not having the intent to commit the felony at the time of a breaking and entering. You decided to break and enter, or you decided to steal. The intent to steal, which is a felony, was after you were already in the home. So there was no breaking and entering involved. So that's a different crime. And we'll go back to that later. So the intent to commit the felony has to be at the time of the breaking and entering. That's really important. The other important part of this is the felony. When you broke and entered into the home, you have the intent to commit a felony. So if you decided that you wanted to go in and you broke and entered into your buddy's home during the night and you were trying to play a practical joke on him by rearranging all the furniture, that's not a felony. You're not intending to commit a felony when you went in. You just were going in to commit a practical joke. So rearranging the furniture or turning the furniture upside down or what have you as a practical joke, that's not going to qualify as committing a felony. So the two important things to look out for, particularly on your exam, is the intent at the time of the breaking and entering and whether or not it was a felony that was intended to be committed. Okay, so those are the elements of burglary: breaking and entering into the dwelling of another during the nighttime with the intent to commit a felony. Another crime against property, and more specifically habitation, is arson. The elements to arson are the intentional burning of the property of another. With the intentional part here, we've talked a little bit about, is the willfully, knowingly, or recklessly intending to set the fire. The next element, burning. Well, what constitutes burning? Well, it needs to have some sort of ignition or spark. And evidence of that would take place by seeing charring of some kind. So if there's charring, that would indicate that there was some sort of flame or ignition. That would constitute burning. If it was a failed attempt at setting a fire and there was only just smoke and no ignition whatsoever, then that's not burning. Has anybody ever tried to build a campfire and all that comes up is just all this smoke and it comes back in your face and you start coughing? Okay, well, that wouldn't be burning for the purposes of this crime. There has to be ignition. There has to be a flame and spark. So even if it goes out, it would still constitute a burning because there would still have been a flame. The next element of the property has the same sort of rules as burglary for dwellings. The property needs to be dwellings and anything in the immediate vicinity of the dwelling, such as garages and barns. And of course, this would be to protect the people that live there, because a fire on a garage that's right next to a home is going to be just as dangerous as just the barn burning or just the home burning. So the idea is that the property, not only does it have to be a dwelling, it still needs to cover the immediate vicinity of that dwelling. The last element is of another. Just like burglary, you can't set fire to your own home for it to be arson under common law. They figure if you're burning down your own home, then you're just being stupid because now you have no place to live. So the idea is that it has to be of somebody else's home in order for it to be arson under common law. Now, I'm sure you realize that today's day and age, that's not necessarily the case, because people set fires to stores and sometimes they set fires to their own home for purposes of collecting the insurance. But under common law, this wasn't really something they thought about. So under common law, it has to be the property of another. And that's arson. The next group of crimes against property are categorized as theft crimes. These crimes include larceny, robbery, false pretenses, forgery, and receiving stolen goods. The first theft crime is larceny. The elements to larceny are the taking and carrying away of another's personal property with the intent to permanently deprive them of that property. The taking and carrying away of another's personal property with the intent to permanently deprive them thereof. Okay, taking. Taking means without permission. You walk up to someone and they're not looking and you pick up their phone and you walk away. Didn't have permission to take it, but you did. So that is the taking. And carrying away. Again, you have to have both. So the carrying away doesn't matter what the distance is. It does not matter how far you carry away. As soon as you pick up the person's phone and take a couple of steps, then it's a carrying away. Even sliding it across the table is going to be carrying it away. You're moving it. So the distance is irrelevant. It's just the carrying away of another's. Once again, the law doesn't recognize that you're going to be stealing from yourself, so it needs to be somebody else's property. Personal property. We talked a little bit about personal property when we discussed the intentional tort of trespass to chattel. Again, this is personal property. It's really hard to take and carry away someone's house that's attached to the ground, so again, it needs to be the personal property. This would be your phones and your backpacks and sunglasses, cars, things like that. Those are all personal property. So you are taking and carrying away someone else's personal property. The last element, which again is going to be the element that I try to trip you up on in your exam, is the intent to permanently deprive the owner of the property. Now, just as there's a little twist in burglary on when the intent to commit the felony takes place, It's the same thing here. The intent to permanently deprive someone of the property is triggered at the time of the taking and carrying away. Okay, so at the time that you picked up the cell phone and carried it away, you had the intent to keep it. You had the intent to keep it. So I'm going to probably try to mess you up a little bit on this one. So please make sure you understand that the intent to deprive the person, the intent to keep the property, then that's triggered at the time of the taking and carrying away. So when you picked up the property and you carried it away, you had the intent to keep it. That means that if you picked it up and carried it away and you intended to keep it, but then you changed your mind, it doesn't matter. The larceny is complete. The larceny is complete. So if I picked up, let's say, somebody's sunglasses, and I walked over and I picked them up, didn't have permission, and I saw them and I thought, you know, I really need some sunglasses. I forgot my sunglasses and it's going to be really tough to drive. So I decide immediately that I'm going to keep them. But then I kind of walk away and then I see my reflection in a window and I have the sunglasses on and I think, oh, those are really ugly. Those are ugly, ugly, ugly sunglasses. I do not want these at all. So I go back and I return them. And the person didn't even realize I took them. That is still larceny because I had the intent at the time I took and carried away the sunglasses. The crime would be complete at that point. It's already done. So even if I changed my mind later, it's irrelevant to the fact that I already had committed the crime. So just be aware of those circumstances. Okay? So if you intended then to just borrow it, let's say that you saw somebody had a really cool hat on and said, hey, can I borrow your hat? And you see it and you're like, okay, thanks, man, I'll give it right back. And then you walk away and then you go into the bathroom and you look at it and you say, wow, I look awesome in this hat. And then at that point you decide to keep it. That's not going to be larceny because you didn't have the intent to keep it when you took it and carried it away under common law. So just be aware of those little tiny tweaks in the elements for larceny. Okay, so that is the crime of larceny. The next crime is robbery. Now, robbery has very few and easy elements to memorize. Robbery is larceny plus force or fear. Larceny plus force or fear. So you have all the elements of larceny, the taking and carrying away of another's property with the intent to permanently deprive them thereof, plus force or fear. So this would be like your muggings in an alley where somebody comes up and holds up a gun against you and says, give me all your money. That's a robbery. Or going into a bank with a gun and threatening the teller in order to get money from them. That would be a robbery. What about, let's say, purse snatching? Would purse snatching be robbery? Yes, because you're using force to pull the purse off the person's shoulder or out of their hands. So that would be a robbery. But what about pickpocketing? Now, pickpocketing, if you're good, the victim doesn't know at all. So which would that be? Well, if it's not robbery, it would be larceny. Now, larceny is one of those crimes that you can always fall back on. It's the catch-all of the theft crimes. So if you can't get to burglary and you can't get to robbery, chances are you can always fall back on larceny. So robbery is just larceny, but now you've added the element and the component of fear or force to the crime. And that's what robbery is. The crime of false pretenses is very similar to the intentional tort of misrepresentation. For false pretenses, you need fraudulently obtaining the title to the property of another by means of knowingly false representations. Fraudulently obtaining the title to the property of another by means of knowingly false representations. The first element, fraudulently, focuses on the intent to cheat or the intent to defraud someone. So you really want to look at what the defendant's end game is. If he's trying to cheat you out of ownership of property, then you've probably got the fraudulently element satisfied. The next element, obtaining. This has an RPP component to it, and the idea of justifiable reliance, just like misrepresentation in intentional torts. If what you said, the false representations that you said, caused the victim to hand over property and the title to that property, then based on what you said, we have to look on whether or not a reasonably prudent person would have relied on what you said and therefore then gave you the title to the property. So when we're looking at obtaining the property, we have to look at whether or not the victim had the RPP standard and had justifiable reliance when the defendant obtained the property. The next element, title to the property of another, has to do with ownership. So this makes it unlike larceny and robbery and burglary, where they just took the property, whether you wanted to give it to them or not. Here, they're getting the property. You're actually giving the defendant ownership and title to that property. And they're doing so based on the next element of false representations. The last element is the knowingly false representation. So that means that the defendant intentionally lied to you or used a half-truth to get you to hand over ownership of property. So it doesn't have to be you just gave them the pink slip or to your car or the keys to your house. Also, just giving somebody money is giving somebody property because the money is yours. And so if you're handing it to the defendant, then you are still giving them title to property because money would be the property. This is often like the example of a bad check. When you write a bad check or you use somebody's credit card and you hand over the check and you write the check, you're telling the merchant that you have money in your account to cover the items that you're about to buy. So you're handing them money, but they're giving you items, but they're doing it under the false representation that you have money to cover it by writing that check. So that would be an example of false pretenses also. And that's more of a theft crime by way of tricking someone. Another crime that is considered to be a theft crime is forgery. Forgery is the making or altering of any writing that changes the legal rights or responsibilities of another. So the making and writing, that means that you are creating something from new, like a passport, or you're altering something like altering perhaps a driver's license or something like that to make it appear different than what it's originally meant to do. Of any writing, that could mean a check, a passport, a driver's license, or anything like that, that will change the legal rights and responsibilities of another person. So for example, if you were to take a driver's license and alter it so that it shows that you're 21, whose rights and responsibilities are you changing at that point? You're changing the state's responsibilities, but you're also changing the responsibilities of any merchant, vendor, or establishment that you plan on using that ID to either get something, buy something, or use something. Which brings us to the crime of uttering. Now, I would say that I'd like to be a fly on the wall when you go to jail and you're sitting in your cell and your cellmate says, "Hey, what are you in for?" I kind of want to be there when you say uttering, because I want to see the look on that cellmate's face. He's probably going to sit there and say, "You did what now? And what, to cows? I don't get it." But the common law crime of uttering is when you're actually using or passing along those forged documents. So this is what that would look like. First, you take a driver's license or a passport and you alter it to make it appear that you're the age of 21. You go to a bar and you take the ID and hand it to the bouncer. And then the bouncer looks at it and then lets you in. Well, the forgery was making the driver's license, and the uttering is handing it to the bouncer. And whose rights are you changing at that point? The legal responsibilities of the bar, the establishment, is now changed because now they're serving what would be a minor, but they don't know it because of the ID that you have. So you're changing their responsibilities of not serving minors, and that opens them up to potential liability and possibly criminal charges. So that is forgery and uttering. The last of the theft crimes is receiving stolen goods. Well, the title of the crime is pretty self-explanatory, but we'll go through the elements anyway. The elements to receiving stolen goods are receiving stolen property, knowing that it's stolen. Well, let's say that somebody comes on up to you and they have this big, long trench coat on. He comes up to you and he says, "How you doing?" And you're all, I'm all right, man. It's all good. I'm good. And he says, "Hey, I got something for you." And you say, "Well, that's cool, man. That's no worries. It's okay. I'm good." He says, "No, really, man. I got something for you." And you say, "All right, what?" And he flies open his trench coat. Now, put your dirty minds away. He's fully clothed, but he's got all this gold jewelry hanging down on the sides of his coat. He's got gold necklaces and gold watches and a gold blow dryer and a gold curling iron. Okay, he's got all this gold stuff hanging from the sides of his trench coat. And he says, "Hey, I got a watch for you." And you say, I was interested in a watch." He says, "I've got this really nice Rolex." And you look at it and you think to yourself, "Wow, this actually looks like a real Rolex." He says, "Yeah, I'll give it to you for $10. And you say, "Oh, well, that sounds like a deal for a genuine Rolex. Cool." So he gives you the watch and you give him the $10. And then all of a sudden you hear this, and you're like, whoa, no, what just happened? And now you have a new silver watch around both of your wrists, and it goes click, click, and you've been arrested for receiving stolen goods. Of course, now what's your argument going to be? You're going to say, "But I didn't know. I didn't know they were stolen." Well, it probably won't work out well for you because the second element of knowing it is stolen has an RPP standard attached to it. That means the question is, would a reasonably prudent person have known it was stolen? Should you have known it was stolen? Well, the answer is probably Yes, because you were buying a genuine Rolex watch for 10 bucks off of some dude in a trench coat. So proving that you didn't realize that it was stolen might be an uphill battle. So again, for the second element of knowing it's stolen, it's knowing or should have known, and that's based on a reasonably prudent person standard. And that would be receiving stolen goods. The other kicker for receiving stolen goods is it's also a crime to sell stolen goods in addition to receiving them. So the crime itself has a couple of other little asterisks with it. With regard to the first element, receiving stolen property, the property does in fact have to be stolen. So if the trench coat example, let's say you got that Rolex, but then it turns out that the Rolex really wasn't stolen, but that the guy had inherited all these pieces of jewelry from his long-lost aunt, but he needed the money, so he was just pawning them off to anyone who was willing to buy it. They aren't stolen. So then you wouldn't have met the first element, and you wouldn't be able to establish that element for receiving stolen goods. So in summary, you have to have receiving stolen property. The property has to have in fact been stolen, and you knew it was stolen, or according to RPP, should have known it was stolen. And that's the last of the theft crimes. Now we're going to move on to what we call white-collar crimes. White-collar crimes is the next group of crimes that we're going to talk about. Let's begin by talking about what is a white-collar crime. A white-collar crime is a crime or illegal act that is committed during legitimate business operations. It is a crime that's committed during legitimate business operations. Some examples of white-collar crimes, and the ones that we'll discuss in this presentation, are embezzlement, mail fraud, bribery, bankruptcy fraud, stealing trade secrets, and insider trading. The first of the white-collar crimes is embezzlement. The elements for embezzlement are the misappropriation of funds or property by the person to whom the funds have been entrusted. Anybody ever have to take one of those bank bags to the bank after a long day at work, and you've been tasked with putting the money into the little bag and then delivering it to the bank? Okay, well, that would be you are entrusted with this money, and let's say that on your way to the bank, a couple of Ben Franklins go missing out of the bag. Okay, well, that would be an example of mishandling or misusing the money that was entrusted to you to take to the bank. Or taking money out of a cash register, oh, thank you for the 20, 120 for the register, 120 for me. Or anybody see the movie Don't Tell Mom the Babysitter's Dead? With Christina Applegate, she would go into the petty cash drawer and take out money so that she could buy groceries for her brothers and sisters while mom and dad were away on a vacation. So any of those situations where you mishandle the money and you were trusted with it is going to be embezzlement. A lot of attorneys get in trouble with this when they have trust funds where they hold large amounts of money on behalf of the client. Well, if they take the money and they dip into it every now and then that would be a misappropriation of that money, a mishandling of that money, and they could be criminally charged. Let's say, though, that it's not necessarily money. It could be property. Let's say you're a valet and somebody comes up with a nice Tesla and you decide, well, that's looking pretty cool. I think I want to take that for a little joyride. And you cruise around town, or a Ferrari. Okay, well, that's mishandling or misappropriating property. You were trusted to take care of the car, to go and park it, but yet you misused it and took advantage of your ability to have access to that car, and you drove it around town. That would be embezzlement also. You still mishandled or misused the property that you were trusted with. So that would be embezzlement. The next white-collar crime is mail fraud. It is a federal crime to use the United States Postal Service to defraud the public. Now, this means that not only is it a crime to mail it yourself, but it is also a crime to just have someone else mail it. So if you just have your secretary put all this mail into the outgoing mail box at your office and then claim, well, I didn't technically mail it, my secretary mailed it. That's not going to work. It is mailing or causing someone to mail for the purpose of defrauding the public. Those are the elements for mail fraud. So it's mailing or causing someone to mail. So just because you technically don't drop the mail into the mailbox yourself, you had someone else do it for you, that's still enough to establish this element for mail fraud. So this is any writing for the purposes of executing a scheme to defraud the public. Now, of course, in modern days, it's more than just mailing a letter or using a stamp. Nowadays, we have electronic mail, and that's where cyber crimes start coming into play. But for this purpose and for the common law crime of mail fraud, these are your elements for the white-collar crimes that we're talking about in this lesson. Anybody see that movie, The Firm, with Tom Cruise? He actually busts a huge law firm under this crime without compromising his confidentiality duty to the client. So he couldn't come out and say that his clients were committing criminal acts, so he used mail fraud because that doesn't breach the confidentiality because they're just invoices to the clients. So he used the invoices that were padded in hours and charging clients for more than what was actually done at the office. And he used that as a means of taking down this firm because mail fraud has quite a hefty fine along with jail time. So that is the white-collar crime of mail fraud. Bribery is another white-collar crime. The elements to bribery are an attempt to influence a public official by way of offering money or goods to act in a way that serves a private interest. Now, the attempt to influence a public official, again, this has to do with officers of the law, officers of the court, anybody in a position of politics or political power. So any public official that you're trying to influence is going to fall under this category. By way of offering money or goods. So you get pulled over for speeding, and the officer comes up to you and says, "Hey, license and registration, please, and proof of insurance." And you say, "Okay, officer, no problem." And when you hand him your license, you've attached a $100 bill wrapped around it, and you give it to him. Now, are you offering goods or money to act in a way that serves a private interest? What's your private interest? Well, your private interest is getting out of the speeding ticket. And you're offering money to a law enforcement officer. That would be bribery. Now again, it doesn't have to just be money. So if you were sitting there in the car and the officer comes up and you decide that you're going to unbutton a few buttons of your shirt and maybe just sort of flirt a little bit and say, oh, isn't there some way that we can work this out? Clearly indicating that you're willing to offer up perhaps something different than money to get out of the ticket. That's still bribery, even though there wasn't a money involved. Goods and services will still work. Now, not only is it bribery to offer the officer the money or the goods or the services, it is also bribery to accept it. So accepting the bribe is also a crime. And once you make that offer, that's the bribery. Even if you try to take it back, once you've made the offer, then you've committed bribery. And once again, it is also bribery to accept it. And that is the white-collar crime of bribery. Bankruptcy fraud is probably not a crime that's very well known, but it is a white-collar crime. We'll be discussing bankruptcy a little bit more later on, and perhaps this crime will make more sense then. But when you file bankruptcy, the courts do not like it when you decide that you're going to hide your assets so that you can get the most out of the bankruptcy by lying to the court. If you hide very nice assets like a couple $1,000,000 home at the beach, or you transfer some of these homes so that you're hiding it from the bankruptcy court, and then once your bankruptcy is done, these other people are going to transfer the property back to you and you're going to be sitting in your couple $1,000,000 home yet once again, that is bankruptcy fraud. And the courts don't like bankruptcy fraud. So this is, like I said, not a very well-known white-collar crime, but yet a white-collar crime nonetheless. These big businesses that file bankruptcy, if they should hide some of the assets that they own, then they are indeed committing bankruptcy fraud. So bankruptcy fraud is still a white-collar crime, and it's usually, in this context, performed during legitimate business operations. And that's bankruptcy fraud. Another white-collar crime has to do with trade secrets. So let's begin by defining what a trade secret is. A trade secret is a process plan or method unique to the manufacturer that gives it an advantage over competitors. A process plan or method that's unique to the manufacturer that gives it that competitive edge. Some examples of trade secrets might be the recipe to Coca-Cola, or the 11 herbs and spices in Colonel Sanders' Kentucky Fried Chicken, or the secret behind bush beans that the dog so diligently protects. Those are all different trade secrets, and it doesn't just have to be food. There are trade secrets with regard to, let's say, what's in WD-40. That's a trade secret. So those are all secrets that are unique to those particular manufacturers, and they don't want them getting out because it allows them to keep their competitive edge in the marketplace. There are places with their trade secrets. If I recall reading somewhere that Coca-Cola actually has their recipe split in half at 2 completely different locations so that people at each of those facilities don't know the ingredients of the other facility. So that would be a trade secret. Anybody ever see Willy Wonka? No, the one with Gene Wilder, the funny one, not the creepy one with Johnny Depp. Well, remember that the guy was trying to get the little kids to steal the famous gobstoppers? Okay, well that would be an attempt to try to steal a trade secret. So stealing the trade secrets is the white-collar crime. Also, receiving them, particularly knowing that they are stolen, is also a white-collar crime. So stealing them themselves and receiving them are both white-collar crimes. Now that's different than insider trading, which is what we will talk about next. The last of the white-collar crimes in this presentation is insider trading. This is the Martha Stewart situation. Does everybody know about Martha Stewart? Well, I should say, do you all know who Martha Stewart is? And do you think that when she went to jail, she made her own curtains in jail? I was always curious about that. Or maybe she went into the kitchen and helped the others cook. Well, regardless, she committed insider trading. And the elements for insider trading are obtaining inside information that has not been made available to the public for the purposes of maximizing stock trading profits. Again, this is the Martha example. Does anybody know why Martha was in jail, aside from lying to Congress? Well, here's what happened with Martha. She was a stockholder in a company, and the CEO of that company was a very good friend of hers, and it was a pharmaceutical company. And basically the simplest explanation of what happened was the drug that the pharmaceutical company was invested in did not get FDA approved. Well, what happens to the stock of a company if your drug doesn't get approved by the FDA? Well, it's going to probably plummet. So the CEO of the company, I Am Cloned, calls Martha and says, hey, we didn't get FDA approved. You might want to sell your stock. And so she does so, and so does he, and so do a couple of other members of the family. Well, then when the news came out the next morning in the official announcement that the drug did not get FDA approved, sure enough, the stocks go flying down and she makes a lot of money off of the deal. Well, that was a little suspicious to the SEC, and so they investigated, and of course she lied at first, and then finally ended up admitting the facts, and she goes to jail. Well, that's exactly what she did with regard to the very elements of this crime. She got inside information, the news that the drug was not FDA approved. It hadn't been made available to the public yet because she got it the night before, and she was doing it so she could maximize her stock profits, meaning that she was selling her stocks while the stocks were still high, knowing that they were going to plummet the next day once the announcement was made. And that would be insider trading, and you can't do that. Now, this is also giving the inside information. So not only is the crime obtaining the information, it is also giving the information. And that's why the CEO got busted as well, because he was giving the information and Martha received the information. So they both got in trouble. Anybody see that movie with Eddie Murphy, Trading Places, with those two old men who really remind me of the two old men in the Muppets? But anyway, the two old guys that were making money off of stocks and come to find out that they would go meet some guy and they would give him inside information, and then Eddie Murphy messes with them and switches out the inside information and they lose everything. Again, another example of insider trading. So insider trading is the last of the white-collar crimes that we're talking about in this presentation. We're going to move along now to organized crimes. Most people have heard of organized crime, and most people associate the mafia when we're talking about organized crime. But it is not necessarily just about the mafia. It's about any organization. So let's begin and define what an organized crime is. An organized crime is an illegitimate operation providing illegal goods or services. So the enterprise itself is dealing with illegal activities, illegal goods and services like drug dealing and things like that. Getting money from illegal goods and services, making the business illegitimate to begin with. The two we're going to talk about, or the 2 points that we're going to talk about, is money laundering and the RICO Act. Those are the two key points that we're going to discuss under organized crimes. And so let's begin with money laundering. The organized crime that we're going to look at is money laundering. Well, money laundering is the process of disguising proceeds from illegally obtained money and make it look legit. So let's say we're looking at drug dealing. And you know what? Forget it. I can't draw a marijuana leaf for the life of me. So I'm just going to make it look like bricks of marijuana. Okay? So we'll start with that. So you get the money from dealing drugs such as marijuana. And all the money that you make from that, you filter it through a legitimate business. You wash it up. Get it? See the washing machine? You wash it, and then it comes out sparkly clean and with no traces of dirty stuff on it whatsoever. So, hence the word laundering, money laundering. So, you're taking the money, you're filtering it through a legitimate business, and then you make it look like it's legitimate on the other end. Now, this is really going to work mostly in cash-operated businesses, such as, coincidentally enough, laundromats, where you go in and you put coins in the laundry machine to do your laundry. Well, who's to say how many people showed up that day putting their cash into the machines? So you sit there and say, wow, we made a lot of money today. We made $5,000 today in people doing laundry. Because who's going to second guess that? Because it's a cash-operated business. Same thing with larger businesses. Can you think of any other huge cash businesses? Well, casinos. Casinos would be the biggest one. And maybe even the racetrack. Or when I was growing up, we would all spend time at the arcade. And you didn't have those little tokens. You had quarters. So it was also a cash business. So anytime you see a cash business, you can think of money laundering. Now, the big mafia influences, there you're looking at the casinos that were in Vegas. That's how they started to filter in the money that they would get from their illegal businesses. So that is the idea of money laundering coming in. And that's the organized crime that we're going to talk about it. But we're not done yet, because now we need to take a look at how the government decided to handle these particular white-collar crimes. And that would be through the RICO Act. The last item that we're going to talk about in this presentation is the RICO Act, the Racketeer Influenced and Corrupt Organization Act of 1970. This is a federal law, and it is designed to go after some of these huge enterprises that are dealing with illegal goods and services, or at least committing illegal acts. The RICO Act does several things. It extends criminal penalties. It provides for triple damages in civil actions, and it defines and goes after racketeering activity or a specific pattern of illegal activity. Now, the RICO Act originally was designed to go after the mafia. It was doing so because leaders or the heads of the families would have their lieutenants and their soldiers do their bidding, and the leaders of these syndicate families were being tried for crimes, but they weren't actually going to jail or being convicted because there was a loophole, because the mafia heads were actually ordering other people to commit the acts and they weren't doing it themselves. So the RICO Act was intended to close that loophole and allow these leaders to now go to jail, or at least go to trial for committing some of these acts and or these orders that they were having other people do. So it was intended originally to go after the mafia. However, it has been extended to other enterprises, such as the Hells Angels have actually been charged under the RICO Act for drug dealing within its organization. The Catholic Church has actually been charged under the RICO Act for the acts by the priests in the church. So the idea is to tighten up that loophole and go after these big organizations, these criminal organizations, for the crimes and illegals acts, the illegal acts that were performed in those businesses. The idea under the RICO Act talks about racketeering activity. Well, racketeering activity is defined as 2 or more listed crimes of this big list that they have in the Act, 2 or more of those crimes within a 10-year period. And there's about 35 of those crimes. And racketeering activity is a pattern of these particular crimes. So 2 or more of the crimes within a 10-year period isn't really a stretch. You imagine that many of these organizations are committing 2 of those crimes a day. So it's not really difficult to pin 2 or more of them in a 10-year period. And along with that, you get a $25,000 fine for each racketeering activity count and 20 years of prison per count. So that's a lot of time in prison. So many of these big entrepreneur type leaders in these syndicate families are a little intimidated by the RICO Act. And so again, the RICO Act is designed to tighten up that loophole that allowed the syndicate leaders to get away with ordering others to commit crimes such as extortion or murder and get away with it. So now they're on the hook for anything that they may have ordered or even assisted in committing and doing. So this act is still in place, it's still going, and like I said, it's now applying to some of these other big business organizations that might be committing illegal acts. And that is the RICO Act. And that concludes this presentation on crimes.